This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a gap in coverage is not necessarily an act of bad faith, and why the United States District Court dismissed multiple counts brought against an insurer, leaving others for trial. Vincent Cusumano and Vincent Cusumano Architect P.C. alleged that the defendants Berkshire Hathaway issued a professional liability policy with a 3-month gap in coverage, which precluded coverage for claims arising from prior work. The plaintiffs asserted 13 causes of action, including breach of contract, promissory, estoppel, and common law fraud. In Vincent Cusumano Architect versus Berkshire Hathaway et al., the United States District Court for the District of New Jersey dismissed multiple causes of action. The court dismissed several counts for the following reasons. 1. Declaratory judgment, or count 1. The court found that the declaratory judgment claim was duplicative of the breach of contract claim, and since the breach of contract claim would resolve the same issue, the declaratory judgment was deemed unnecessary. Specific performance, count 2. The court dismissed this claim because specific performance is an equitable remedy, not an independent cause of action. Plaintiffs cannot amend the complaint through opposition briefs. Next, breach of contract. The court dismissed this claim because the plaintiffs failed to identify a provision within the insurance contract that the defendants breached. The policy terms were clear and did not cover the underlying claim. Fourth, quantum merit, or unjust enrichment. The court dismissed this claim because the existence of an express and enforceable contract, the Berkshire policy, precludes a claim for unjust enrichment. Breach of covenant of good faith and fair dealing, count 6. The court dismissed this claim as it was duplicative of the breach of contract claim and failed to establish bad faith under New Jersey law. Common law fraud, count 7. The court dismissed this claim because the plaintiff could not establish reasonable reliance in the face of clear, contradictory language in the insurance policy. And finally, breach of fiduciary duty, count 12. The court dismissed this claim because the insurance agent owed a fiduciary duty to the insurance company, not to the insured. The court determined that the suit can proceed on the remaining counts, but concluded that the 7 counts dismissed were simply not viable. In my opinion, when a person or entity sues an insurance company, they often throw in the kitchen sink of causes of action. The architect did just that, and found that 7 of at least 13 causes of action were not viable, and the remaining counts will be either subject to an additional motion for summary judgment or were resolved at trial. It is, in my opinion, best to simply state what is your claim in short and simple language and in single counts. Adding 13 counts together just upset the court because it had to rule to get rid of 7 of the 13. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you do, you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,000 blog postings. You can also subscribe to these videos on YouTube and on rumble.com, and if you do, please click on the like button on YouTube or the thumbs up button on rumble.com. And I'd appreciate it if you would tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.